Chahar, a distinguished senior advocate of Supreme Court of India, who readily accepted our invitation to visit DSNLU, and it is his first visit to Visakhapatnam, and he felt very happy to interact with our students. All this is possible because of our strong alumni. So, in Delhi, Supreme Court and various high courts, DSNLU alumni occupied different important positions. They are even in Andhra Pradesh High Court and Telangana High Court also. Our alumni are active advocates, and it shows the significance and importance of DSNLU. Slowly, DSNLU is visible at national level. Recently, we all know in India Today rankings, our university gets first place in the progressive, most developing university, fast developing university. We got first rank, and out of almost 27 national universities, our university got 7th rank in 26. That is also a happy note to all the visibility of DSNLU. And as we know, just now I shared with you, in law colleges in those days, generally the subjects were taught. BL means boarding and lodging. In those days, it was known as BL and ML. Madras University model. Of course, in 1998, there should be uniformity in awarding the degree, that is LLB. Prior to that, there was ML and BL in Madras. BL means boarding and lodging. So after having MA and other discipline, before getting a job, just to prepare for competitive exams, BL degree was the studying BL was considered. But now, in the post-liberalization era and the contemporary progressive societies, particularly like India, the importance of legal profession increased like anything. Now we all talk about the rights, human rights concept, and rights of different sections of the society, privileged, underprivileged, women, children. And now today also there is a South region conference on women and justice in Bangalore. Actually, I skipped that second day program of Bangalore. I attended yesterday because our sir is coming to our university. Today, our Justice Lesa Gill, the Chief Justice of Andhra Pradesh High Court, is presiding the valedictory function, and in which Justice Mohan, recently appointed as Supreme Court Judge, directly elevated from bar. So she is giving a valedictory address. So nowadays, every concept, justice demanded by each and everybody, individual level and group level, society level, and national level also. So, particularly the function of courts. The primary function of any criminal court is to establish rule of law and to identify the guilty or proving or disproving or non-proving of the liability or the accusation leveled against a particular accused. So all these are there. So, but in present day contemporary society, law plays an important role. So, like with our all social sciences, law plays an important role. Law is law keeps on changing with the changing needs of the society, so that law will be modulated, law to be formulated in such way that it should be suitable to solve the societal problems, whether they are specific individual problems, women-oriented problems, children-oriented problems, or aged people-oriented problems, or underprivileged. So in that way, our Constitution of India also played an important role to provide transformative justice. So in the process of providing transformative justice, our legal system works. So where still now independence of judiciary plays an important role in promoting the democratic values and everything. Being the court officer, our chief guest has a personal experience of the functioning of the Supreme Court of India. So I welcome our chief guest, the Additional Solicitor General of India to DSNLU. Thank you very much, sir, for your presence here today. Thank you very much. Thank you very much for being here. Thank you.
Thank you, sir, for your gracious words and for setting the tone for today.
That corporate is glorified. But once you will try to understand that where litigation can take you, you will go out of this room by taking inspiration that this is something I can work upon, and the process will take me to places which will never be achievable in normal course of area. So I want to say that whatever he will say today is not just about your theoretical knowledge. He will share the experiences that how he started approaching the law in his initial days to till today after his 43 years of practice. And I think as someone who has been on that side for the longest period and to this side, I understand that if you start learning from your seniors and their experiences, things will change for better, because I cannot be doing everything at every point of time. So that is one of the most important things. So I know you all want to go out of this place and you are here, most of you are here for attendance, but just listen to sir for better of yourself, and I can assure you one thing, that he has bring a transformative change to most of the people's life during his career, because he has started his career in 86. So for his brief introduction, I will just say that he had done his education from best of the institutes. He started from Winburg Allen in Missouri, then went to DAV in Chandigarh, then did his law from Campus Law Center, Delhi University. Amongst his contemporary were Justice U.U. Lalit, our Justice P.S. Narasimha during the same time. Then in 90s, he was one of the rare exceptions that without being an advocate on record, he became standing counsel for State of Sikkim, and that too on the personal invitation of our longest serving Chief Minister of the country, Mr. Pawan Chamle. And from 90s till 2007, he was the standing counsel for the State of Sikkim. During that tenure, he was also offered the position of Advocate General for the state, but because of his commitment to Delhi, he could not take the same. Then he was designated as a senior advocate in 2007. Then he was in the position of a special counsel to the State of Sikkim as well as Government of India many times. Then in 2024, he became the Additional Solicitor General of India for Supreme Court. And during his tenure, in the limited tenure of 1.5 years, he has attended few of the prime cases. That is about the marking of Aravali Hills, that what should be the limit. Second one being the arbitration which took place in London for 12 days against the Vedanta on behalf of Government of India. And now recently, the recent one was interpretation of 498A IPC in terms of whether living relationships would be applicable on those cruelty provisions or not. So such is his experience. And I, as an alumni, is not speaking about someone who has coordinated this, but I am speaking as someone who has been the junior in the court, and those who really want to do something in disputes, if you want to go on that corporate advent also, then this is the place. Because seniors taking time coming to this place, for example, Siddharth Luthra used to come in our times, after that many other seniors came. Now after many years, people have started coming from Supreme Court. So take out some time from your busy schedules and your phones, just listen to him, and I think you will get a different perspective of litigation. So I hope you all will be present with me, and specifically my junior colleagues. So thank you very much. I introduce sir to give the address.
And also reminds me of all the silly things we did then. But fortunately there were no mobiles or media. So we got away with it all. And one incident, one silly incident I can narrate, which you all can connect. But we were foolish then. I'm sure this present lot is more intelligent and knows the importance of learning in the class and take advantage. One more thing I'll also share. Nowadays, you guys study from whatever is taught in class and books and internet. During our times, you had the option of attending class, and for us ordinary people, we used to have those dukis. They used to call them guides. About 110 pages summary of the whole subject. So like-minded people like me who didn't understand the importance of what is being taught in class, when the exam days used to come, there was a friend of mine, Yoginder, he later went on to become a big shot, commissioner, etc. He's retired. We would both buy one duki, tear it into half. I would read one and narrate to him, and he would narrate the other half and tell me what it was, irrespective of what the syllabus was. And mind you, in those 3 years, we never got a supply. Important thing is your concept should be clear. That duki clear the concept. But I'm not advising, again I will repeat, at your peril, do not follow what I did. I'm only sharing that there was nobody to guide us actually. So we did all these silly things. Two things I wish to, from my experience of 40 years in the Supreme Court, I want to share with you youngsters. The present lot is in a hurry. You want everything very fast. Sabr nahi hai. First principle I want to share with you is maintain work-life balance. All the youngsters who have interned with me or who have started practice, their view about this profession is that first 8, 10, 15 years they are going to slog day and night, law firms, corporates here, and then when they have settled down, financially and professionally comfortable, they will start enjoying life. No. Strictly no. My advice is you must have work-life balance. These initial 10 years of your profession which you intend to slog day and night, they will never come back. So that work-life balance is a must. Trilegal is a law firm in Delhi. I know some people who have worked there and left. There you are supposed, they say we have employed you 24 hours. They work till 2, 3 in the night, there's a place for them to stay, to eat, there's a gym. But there's a burnout. You shouldn't risk that. So my first funda to you is work hard, party harder. That's very important. Second is, which I have noticed is, there's a phrase, jack of all, master of none. Nowadays, I've seen youngsters wanting to specialize in a particular field from day one. My suggestion is that in the first few years of life, try to do all subjects and try to attend all forums. Because, you see, after 8, 10 years of practice, I don't want to see some client approaches you, whether he has a problem of contract, MACT, NGT, Armed Forces Tribunal, you name it, such a wide range of subjects. I don't want to see you say, I have no clue, brother. So, first few years of life, try to work in different offices and gain experience in as many fields as possible, and then specialize. That's my second suggestion. Now, just briefly, I'll share my journey. Harsh told me that I've studied in the most elite of schools. He forgot to mention where I actually started. I was born in a village, small village in Silani, in Tehsil, Jhajjar, Haryana. And those days we had only one school in that whole Tehsil, Kendriya Vidyalaya, Jhajjar bolte the school. And those days, till class 5, we did not have desk or table to sit on. We were not given paper, pencil to write on. We used to have those jute tarts on the floor. And we used to have takti, that wooden thing you, yes, wooden slate you can call, and kalam. Kalam or sarkhande ko we used to chakku se chheel ke, we used to make it a kalam, dip and write. So I started my career from there, Kendriya Vidyalaya. Those days, beating was so common. Teachers, haath kholne ke liye maar dete the, for no reason. And our parents were okay with it. But one incident turned my life. We used to have maths teacher, Ajit Master, he used to wear a ring, with a big knob on it, and used to keep rotating. One day I had not finished my homework, so he came checking, he saw not completed, whack. Unfortunately, it hit the corner of my eye, but today I can see with both eyes, otherwise I would have one stone one. So, by the time I reached home, my eye was this. My father was a trial court lawyer. He returned in the afternoon from courts, and he asked what happened. I said, I've not done my homework, and this is what he did. So my mom said, look, get him out of this place. It is then that class 3 my father sent me to Weinberg Island School. Those from 3rd to 8th I studied there. If I look back in life, I think that was my golden phase. Not then. When we were in school, we thought, too many restrictions, we used to hate it. But when you leave school, you realize what a blessed place it was. So, you heard of Ruskin Bond, that famous author. His house was right next to our junior school. Every Wednesday, he used to come to our dormitory and tell us stories. We didn't know he would become the famous Ruskin Bond. So, and another thing I liked about school hostel life was it was regulated. There's a bell, you get up at 6 in the morning, there's sports, breakfast. In the evening, we used to have hockey season, football season, athletic season. Well, we were occupied and involved all the time. We had no free time to do any mischief. And so that we don't write any complaint about the school or some teacher is not this, food is not good, whatever. Maybe that was the reason. But the letter would start with, my dear mummy and daddy. So we used to come to school in March and go back in November end. During summers for 1 week, parents were allowed to come to Mussoorie. We were not allowed to leave Mussoorie. So one of these years, parents got together and said, this is wrong. My child addresses me as Ma. Why does he write mummy in the letter? So they met the principal. And this diversion was allowed from class 4, when I was in class 4. That you can address your my dear Ma and Pitaji or whatever, but the content of the letter remained the same. And after we wrote that letter, in junior school we used to be given ₹3 as pocket money, and in senior school ₹5. But those good old days were, in those ₹5, once a month we were allowed to go out to town. In those 5 we could have one lunch and see a movie. Golden days. Those were good old days. Then from Mussoorie, 9th and 10th I did from Mount St. Mary's, Delhi, Kent. And I went on to do my geography honours from DAV, Chandigarh. Then came the most colourful period, Campus Law Centre, New Delhi, 1983 to 86. I stayed in Jubilee Hall, hostel there. I noticed all of you guys are spoiled kids, yeah? Everything AC. Classroom, dining hall. We were not even, we were given one fan in the hostel, and there was no AC, not in the classroom, library, nowhere, unheard of. And some of the rich guys, they wanted to seek permission to put a cooler in their hostel room, refused. But you guys are lucky, really lucky. And in that Jubilee Hall hostel, while I was studying law, everybody was preparing for competitive exams. And most of my friends, except me, for me, law was my first option. I didn't take any competitive exams. So most of my friends, they got through IAS, IFS, Forest Service, State Civil Service. So after, I started litigation right in the beginning. So after 2-3 years, when anybody would come to Delhi, they would ask, Chahar, how's it going? I said, struggling, brother, struggling. Then they would taunt me, a friendly gesture that, if you had studied at the right time, you would also have a red light on your car. They had become SDMs and all after becoming IAS. Anyway, life went on. After 60, they have retired. And now, when they call me in the evening, Chahar, what are you doing? I said, no time, brother, no time. Team conference ho gayi hai, 4 aur bachi hui hai. Now, I joke with them. Now, I tell them, at that time, if you had mustered the guts to do litigation, you would also be busy. And there is no retirement in this profession. So, I'm loving it. I'll share it. So in 1986, when I started my profession in Supreme Court, I went to one senior, the second and the third. I wanted to join their office. So all three were unanimous when they said ki, nahi son, don't even think about it. I'm a judge from Haryana. He said judges are not competent nor suitable nor deserving to practice in Supreme Court. In 1986, there were only 2 judge advocates. So I was considering starting my practice in Chandigarh High Court. But my father said, beta, we are not the ones to run away from the battlefield. You are going to start here and here only. So that, I was determined to prove those people wrong. I think I did. That was 40 years ago. Things had changed for me. I started in the Supreme Court. I took up residence on the outskirts of Delhi, Nangloi, if somebody's heard of Delhi. But I had a Bajaj Chetak scooter then. I felt in court religiously, without work. I would sit in the library, sit in the courtrooms, and slowly and slowly. And later I won 4 elections in the Supreme Court Bar Association. I contested 4 and won all 4. And I was designated as a senior advocate before I turned 45. This was my reply to those who thought I should not practice here. And underlying request or advice to you is, if from a small village in Silani to ASGI today, I can do it, all of you can. Nothing can stop you. Now, in the courtrooms, bar is as important a place to learn as a courtroom. Not the bar that you're thinking of. Bar room. I'll again clarify, the bar room, not the bar. Because in the bar room, the lawyers at leisure, they sit and discuss and criticize and praise and conduct post-mortem of the judges. Who said what, who said why. So from that conversation in the bar rooms, you learn which judge likes what. Some judges want you to come straight to the point when the item is called. Some judges want you to give the background. First tell me what happened in the trial court, what happened in the high court. So from all this knowledge that you gain in the bar room, it's very helpful to present your case in the courtroom. It's very important to know your judge. And like Harsh was also saying, that one life is too short to learn everything from your own mistakes. You should learn from others. That's very important. And a judge had once said that both the lawyers on both sides, and the clients on both sides, they know who's right, who's wrong. It is the judge who is on trial. The Delhi High Court judge had once commented, you know the truth, yeah, I am on trial to find out who is right. So that's also true. Another thing I want to share is, I have seen lawyers, they are arguing in court, presenting their matter. In the midst of his argument, the judge asks a question. Now, what did the trial court say on this point? I have seen lawyers who commit this blunder. They say that, Milord, I will come to that, but kindly have page so and so first. You've lost half your case. Golden principle is, whenever a question is put to you by the judge, leave everything, answer that. If If you satisfy the judge, you won your case. So you should not commit that mistake. Next I want to share is, no court is high or low. Some people leave the law college saying, I want to start practicing in Supreme Court. And they get matters, they get offers of attending in trial court or consumer court. They say, no, I'm Supreme Court only. What I want to tell you is, no court is small or big. Ashok Sen, I remember, when he was at his prime, he had attended a case before a magistrate in Ghaziabad. So some of his colleagues while sitting in the library said, Ashok, magistrate, Ghaziabad, what are you doing? So he said that no court is big or small. He even went to the extent of saying, you pay my fees, I'll argue before a lamppost also. So a lawyer he's paid his fees to convey his case, in whatever manner. My experience of trial, I've done some, not trial as such, but I've argued matters before trial courts. One experience was that there was a case where a TV channel was running a scroll. News is going on, but there's a scroll at the bottom of the screen that against a very famous builder that he has cheated the government of so and so crores. And then a phone came to that builder from that TV channel that you come and meet us, otherwise we'll run the whole story. So that builder had filed a civil suit for injunction in the Saket court, where I had gone to argue. So during that arguments, that TV channel guys, their main thrust was on, look, we are the fourth estate. When the legislature, executive, judiciary, they falter, it is we, who protect the people's rights. It's we who bring everything to the people's notice. There's nobody more pious than us. So the matter went on for 2 days, 3 days. So I told the judge, when they were boasting too much about themselves, so I told the judge, my lord, apart from this case, I want to share my experience with the fourth estate. In 2009, I contested MLA election in Haryana. So I was not given the party ticket. On the last day, tomorrow is the last day for nomination, one night before they declared somebody else's ticket. So I also fixed up a public meeting and I filed my nomination next morning. So after the nomination, when I came back, all the press people were there, print, media. So they said, when you are free from the public, we want to meet you for 10 minutes. So after all the people had gone, all of them presented their rate charts, I would call it, or schedule. So I said, what is this? He said, now this is the rate. If you want your news so many centimeters or so many centimeters on the front page, this much, fourth page, this much. And if you want so many minutes of bite at prime time on so and so TV, this is the rate. I said, oh, it's exorbitant. I can't, no party is funding me, I am independent, I can't. Warning me that there will be a complete blackout. We will not mention your name and TV or newspaper. There are 100 villages in your constituency. In one day you will village 4 villages, 5, 6. In the remaining 95 villages, there will be no mention of you. On the third day, I had to call them and take their package. That was my experience with the fourth estate in the trial court. Ultimately, they were settled between the parties, but that was my experience. Now, I'll come little to the relevant thing for which I'll tell you. It's not a lecture, I must again tell you. I want to share nothing legal, something about mediation. Mediation Act has come, a lot of people are talking about it, and I'm in favor of mediation certainly. Because mediation is the art of winning without losing. Because litigation gets you a judgment, mediation lets you write your own. That's the beauty of mediation. Now I'll just read some things for you. One of the greatest ironies of modern legal discourse is that mediation is often described as an alternative dispute resolution mechanism. I differ. Alternative to what? If history is our guide, mediation is not the alternative. litigation is the alternative. Communities instinctively understood that living together demanded conversation far more than confrontation. The instinct to sit together and search for common ground is perhaps as old as civilization. When Mediation Act 23 came into force, many spoke as though mediation itself has suddenly entered Indian jurisprudence. Nothing could be further from truth. The Act deserves celebration, not because it invented mediation, but because it formally recognized a wisdom that Indian society had quietly practiced for centuries. Parliament did not create mediation, it honored it. Property can be divided, money can be calculated, contracts can be rewritten, but convincing two individuals that compromise is not surrender, but tested civilization from the age of Mahabharata to the age of commercial arbitration. Every experienced mediator eventually discovers that human ego has remarkable staying power. It survives facts, logic, and occasionally even good legal advice. Courts exist to decide disputes according to law. Mediation pursues a different though equally valuable objective. It asks whether a dispute can end without permanently damaging the relationship that gave rise to it. A judgment can determine ownership. It cannot persuade two brothers to celebrate Diwali together. A decree can dissolve a partnership. It cannot build trust between former friends. The judiciary itself recognized many years ago there had to be a more effective way of dealing with disputes that are capable of settlement. This recognition found expression through judicial initiatives, lok adalats, conciliation, arbitration, and eventually the court-annexed mediation centers that many high courts established with remarkable success. Section 89 of the Civil Procedure Code talks about settlement of disputes outside the court. This was one of the earliest statutory acknowledgements that litigation should not always be the first instinct of legal system. It encouraged courts to explore settlement wherever the circumstances permitted. The provision was simple in language but profound in philosophy. Over the years, mediation quietly proved its worth. Matrimonial disputes that appeared irreconcilable found unexpected solutions. Commercial agreements involving years of business relationships were resolved without destroying future partnerships. Property disputes that had traveled across generations finally reached closure because parties discovered that peace was considerably less expensive than prolonged litigation. One of the most significant contributions of the Act is its emphasis on pre-litigation mediation. That single idea has the potential to transform the culture of dispute resolution in India. It invites parties to explore dialogue before positions become permanent and before legal costs begin competing with the value of the dispute itself. It is rather like repairing a leaking roof before the monsoon arrives. It requires far less effort and produces considerable better results. Another great strength of the Act lies in unwavering commitment to confidentiality. Litigation is necessarily public, arguments are advanced in open courts, pleadings become part of judicial records and decisions, and are published for future generations and lawyers to analyze. Mediation operates on an entirely different environment. It creates a safe space where parties can admit mistakes, acknowledge misunderstandings, explore creative solutions without fearing that every statement may later return to haunt them in subsequent proceedings. That perhaps is the mediation's greatest contribution. It encourages candor where litigation often encourages caution. Many citizens continue to believe that justice is synonymous with courtrooms and that compromise somehow represents weakness. In reality, a successful mediation often requires greater courage than prolonged litigation. Mediation has steadily moved from the margins of our justice delivery system to its very center. The transformation is perhaps best reflected in one of Supreme Court's most inspiring recent initiatives, Samadhan Samaro. The Supreme Court's initiative of Samadhan Samaro deserves appreciation, not merely because of the number of cases it seeks to settle, but because of the philosophy it represents. Supreme Court consciously chose the word Samadhan, meaning solution. More importantly, it transcribes the initiative as a samaro, celebration. That choice of language is itself significant. It tells every litigant that resolving a dispute is not a compromise with justice. It is often the highest expression of justice. A legal system should celebrate not only those who win cases, but also those who have the wisdom to end disputes. Samadhan Samaro, organized by the Supreme Court from 21st to 23rd August this year, is therefore not merely another judicial event, it is a message. Thousands of matters were identified for settlement, a substantial number was successfully resolved, and countless hours of valuable judicial time was conserved. Yet, if I may respectfully submit that the most remarkable achievements of Samadhan Samaro cannot be measured in statistics alone. Now, this is important. No annual report can calculate the number of relationships restored. No spreadsheet records the number of children who watched their parents stop litigating. No chart reflects the number of businesses that survived because partners chose conversation over confrontation. Some of the greatest successes of mediation will, however, remain invisible because peace rarely makes headlines. Launched by the Chief Justice of India on 21st April 26, the initiative runs for 4 months and culminates in a special Lok Adalat at the Supreme Court itself on 21st, 22nd and 23rd August this year, which appropriately is right around the corner from today. A meeting of law officers of Supreme Court was called by the Committee of Samadhan Samaro, and when it came to compromising cases with the government, with the departments, the officers attending the Samadhan Samaro, they expressed their inability that we don't have the instructions to compromise. Our rules do not allow. There is no policy. So in that meeting with the Chief Justice of India held with all the law officers and the judges of the committee and members, office bearers of Supreme Court Bar Association and SCORA, it was in the presence of the Attorney General and Solicitor General. It was decided that because government is the biggest litigant, whether it's against the government or the government challenges something, so it was decided in that meeting that all departments will form committees with the head of the department, finance and HR. They will have a list of cases, pending cases which will be given to them. They will form a policy that, for example, land acquisition matters will say if the compensation has been increased only by not beyond 20%, settle. Compassionate appointments, pension matters. So committees were formed, policy decisions have been taken. Now on the basis of those, the government, where government is one of the parties, the matters are going to be settled in right earnest. In this year, Samadhan Samaro has identified 45,098 cases pending in Supreme Court which are suitable for settlement. Though the final settlement figures will only come to light once the special Samadhan Samaro ends on 23rd August. Even if a fraction of this historical figure of 45,098 hand-picked Supreme Court vetted matters heading into August, this could be one of the most productive week in the history of Indian dispute resolution. 3 days in the apex court quietly clears more matters through consent than most benches manage through contested hearing in a year. Does so without a single dramatic objection, my lord. A final quietus to the dispute. Now, to every person, every student present here, I would say to every future litigator in this room, eyeing a glamorous career of cross-examination, dramatic objections, chase it. Do enjoy the theoretics. But do remember what the Panchayat under the tree knew, what section 89 of the Civil Procedure Code eventually admitted, and what Supreme Court is now betting on. I am leaving this food for thought for you bright minds, the champions of the future. Think about mediation also. The answer, solution, according to me, lies in education. We teach our law students how to draft claims, written statements, appeals, specially petitions. We teach them the art of advocacy with admirable thoroughness. Perhaps the time has come to devote equal attention to teaching them the art of listening. Every law school should have mediation clinics where students learn that resolving disputes is as noble as arguing them. A lawyer should graduate not merely knowing how to win a case, but also knowing how to resolve it. Secondly, with mediation coming to the forefront, I believe that there is tremendous scope for specialized mediation. Commercial disputes require mediators who understand business realities. Family disputes require sensitivity and empathy. Environmental disputes often involve multiple stakeholders and scientific complexities. Government litigation requires an understanding of public administration and public interest. As our legal systems evolve, mediation too must become increasingly specialized, enabling parties to benefit from mediators possessing domain-specific expertise. It was not what I had come prepared for, but last night my daughter happened to call me. He said, "Dad, 2 minutes on AI, because the people who will be sitting in front of you, for them AI is inseparable part of their lives." So, pardon me, I did use ChatGPT because I have no clue about AI otherwise. So I've just jotted down a few lines on AI. One says AI never complains. The best thing about AI is that it never complains. It doesn't ask, "Sir, may I leave early today?" or "I have a family function." It doesn't ask for weekends off. It doesn't even ask for coffee. But if AI starts practicing in Indian courts and knowing how quickly it adapts to the system, it won't be long before AI starts saying, "My lord, one adjournment please." That they will adapt. And one father introduces AI to his son. Gives him a phone. He says, "Dad," he says, "Son, this AI will do everything for you." The 10-year-old son. So the son asks, "Dad, can it convince mom for me to play video games before I complete my homework?" Dad took the phone away. Some things are beyond technology. Thank you, Jai Hind.
Thank you, sir, for your students to make most of this opportunity to interact with the guest. The floor is open for questions.
Interested or even thinking about litigation as a career, this is your opportunity to learn from 43 years of experience and ask silly questions. Ask any questions which are there in mind. Don't refrain, don't restrain. We have time, this is the opportunity, and utilize it to the fullest. So please, students, don't miss the opportunity to ask your questions which are related to litigation, because our whole agenda of organizing this was that you see the different side of practice, that what hard work, what persistence and what consistency can build you. There is corporate, there are other things, there are things which will give you early success. But this is your time, sir is here, and I can assure you, your silly questions would be asked in the most decent and most politeful manner, because he understands that where you are coming from. So please take the floor. I want good questions or I want silly questions, but ask questions. Don't just sit here and just go away from this class.
I am Marna. I am in 5 years LLB course and I am a first year student. So when you talk about work-life balance, so in college only I am not able to balance it out. How do you manage to do it in such a great position of your life? Like, because we have to read so many things, we have to explore so many things, and we just have 24 hours. How do you do it?
For example, I can only give an example because I also stayed in the hostel. If you want to work-life balance, for example, you want to take a stroll around the campus with your friends at least for 1 hour to unwind. You set an alarm. 6 o'clock, whatever you're reading, in the midst of anything, just leave it, go out. Mind you, when you come back refreshed, you'll make up for it. You learn faster. If you're constantly at the desk, your receptive power reduces. You go out, fresh air, chat, laugh, joke, you'll make up for it.
Question to you is that as a rising litigant or a mediator, what are some of the biggest challenges that one can face, and how do you deal with them? Because in your long experience of planning the legal system and the ladder, you must have faced several issues, and how are you able to deal with them?
I won't call it a hurdle, but reality is it's going to take time. Sabr. Unlike those students who after law college join a law firm or join a corporate, from first month they are getting a salary. It's very tempting. But if you are interested in litigation, 5 years minimum 5 years to break even your cost and expenses and your earnings. So that is an inevitable risk, and you need to muster that courage. Sabr is important. There's no escape from that.
Good morning, sir. My name is Uncle, and as you mentioned right now that it takes at least 5 years, and as a first generation lawyer, it not only is it tempting to join a corporate, but also some students might need that method because they can't depend on their family after their education is completed, right? So for lawyers who want to join litigation and start doing practice, but don't have the option for that because they can't depend on their families further, what would you say? Like, what do they do after their education is completed?
In the litigation team, law firms have corporate contracts, litigation. You see, so in that law firm, there are options when they are searching for lawyers in the litigation team. Join the litigation team in that law firm, and after a few years, when you've earned enough money to sustain yourself for a year or two, you gain the experience, then take the plunge into litigation. There are black sheep in every profession. I think there will be a handful of seniors who do not pay their juniors, and I paint them as black sheep. No senior should take the services of a junior without paying them. No way. But I do agree, like every other profession, there are large number of lawyers entering the field. But for anybody who is firm on his feet, with a resolve that I can and I will, there is no dearth of work. Lawyers are increasing in numbers, so is litigation. One advice I'll give you, when you want to join a senior, search for an office, the office which has work in which you are interested. For example, you are interested in criminal work, and there's one senior who is willing to take you, but he has only got civil matters. So take time, find a senior, you will find plenty. I assure you that. And all of you will pay you. I assure you that also. But find a senior and an office which has the subject which interests you. That's it.
Second year 3 LLB. My question is, when it is being considered to mandate 3-year LLB practice rule, why do not discuss on relaxing the upper age limit? Because the 3-year LLB itself has no upper age limit. So when the degree itself has no age limit, then do you think 3-year LLB practice rule without age relaxation will be bar people from writing judiciary exam merely due to age limits?
If I have understood you correctly, you are saying that for 3-year law graduates, there should not be compulsory few years of practice before you can take the judiciary exam.
No sir, age limit sir, I am talking about age limit. In pursuing 3-year LLB,
I can't.
It's not involved. How would you manage your grounding ability and detach from the law or your own self-will or giving for someone?
Litigating for about 30,000 crores dispute, that's high stakes.
Yes, sir.
But a poor man, he has 2 acres of land, government has acquired 1.5. For him it is high stakes.
Yes, sir.
For a person who is in service, he has not been promoted, juniors have put on his head. That's high stake.
Yes, sir.
So high stake is very subjective. For everybody who goes to courts, everybody who has something to heart, it is high stake. So a lawyer should be as sensitive about presenting the case, whether it's a 30,000 crore matter or a promotion matter. For a lawyer, everything should be high stake.
That according to you, what are the primary skills that I should be working upon for becoming a good advocate as somebody who has just begun their journey in law school?
And ears open. That's one. Rest. Spend time at the bar room. Court में तो बैठेंगे आप. Actually, if you are in, I think the fundamental is if you are really interested in a profession, everything will fall. If you join the profession for various reasons, whether parents have said it or your friends were joining it, then every day is going to be a burden. So interest kind of every day will be a holiday. Like every new case has its own legs to stand on. So just keep your eyes and ears open and stay at it. That's all.
Thank you, sir.
How do you handle a case when law is not clearly in favor of your client?
See, if the law is against my client, that's half the battle lost already, even before I go to court. Then when the matter is listed, we do have some inclination as to which judge is pro-tenant, which judge is pro-landlord, which judge is pro-farmers, which judge is pro-government. We have a fair idea. So if it is listed before a judge who is not going to pass a favorable order, then typical Sunny Deol dialogue, Tariq till the judge changes, and hope. For the next judge that he's a favorable one. That's it.
And my question is, many lawyers wanted to enter public life and politics. So what are the qualities do we need to develop as an young lawyers who want to contribute to good governance and policies?
This question relates directly to me. I was happily practicing in the Supreme Court. My father, initial days, 60s and 70s, he was MLA twice, independent, but then he gave up politics long back. So, we were sitting at a former Haryana Chief Minister's house. So, my father and he were discussing something about politics. So, I was quietly sitting on the side. So, out of the blue, that former CM said, "Brijender, you are very selfish." I said, "I didn't say anything." He said, "No, we are trying to set up our new party so that we can bring change in Haryana, and you are not contributing anything." So my reflex reaction was, "Babaji, politics is for the corrupt. I don't fit in." So he lectured me, saying it's people like you sitting in the drawing rooms saying politicians are corrupt. If you think you are different, come in the field and make a difference. It is that what prompted me to enter politics. I spent a couple of years. It took a big hit on my profession. My village was about 3 hours from Delhi. So I used to, Mondays, Fridays, I used to be in Supreme Court, rest 3 days in the field, every house, every chopal. I spent a number of years. But when it came to the ticket, they refused. So at that time, the person who was in charge of the state from the central government, from central party headquarters, I had met him 10 days before the elections. Like as a tickarthi, you know, I am also claiming a ticket, I also need a ticket, so I met him, I gave him my CV and told him about what I've done in the constituency, what are my qualities. So I was surprised by the frank answer he gave me. He said, Mr. Chahar, you will not be given the ticket. This was 10 days before it was finally announced. I said, why? I told you all my plus points. My father's legacy, my father set up so many schools, colleges, canals, and what I had done for the constituency. He said, no, all these are your minus points. Because the boss in the state, he was from our district. He said he will not allow people like you to have roots in his home district. And he was right. I was not given the ticket. So there is no quality which you can inculcate to be successful in politics. Just be good at heart, yeah. And only when an opportunity is given, that is when you will have to prove that you are different from the lot.
Was the toughest part of arguing before Constitution bench versus regular division bench? And as a junior, what are the skills we need to start developing now to argue in Supreme Court after 8 or 9 years later?
For a division bench and the constitution bench is that there are more firing pods firing at you. Instead of 2, there are 5 people shooting questions at you. That's one. And otherwise, it's a pleasure arguing for a constitution bench because, you know, constitution bench settles a dispute which 2 judges or 3 judges have not been able to. There is one last matter I did before a constitution bench was Dharampal. You will find Dharampal criminal ka hai. Power of a magistrate to summon a witness, to summon an accused in a case triable by session. For example, it's a 302 murder case. But every challan is filed before a magistrate. So the magistrate is supposed to, if he sees the offences, if it's triable by session, he is supposed to send it to the session judge. That was my argument. That magistrate is only a post office. He just sees the offence and sends it to the sessions. But my argument was struck down, and the Supreme Court Constitutional Bench has held that magistrate is not a mere post office. If, for example, in that FIR, which I was dealing murder case, there were 5 accused. The police kept only 2 accused in the challan and removed the other 3. The magistrate summoned the other 3 accused who were my clients. That I find there is sufficient material in the charge sheet against you, so he summoned them. Against which my client went to the High Court, Supreme Court. So for the 2 judges, I had a judgment of 2 judges in my favor, and the other side had a judgment of 2 judges in their favor. So the judges referred it to 3 judges. Before the 3 judges, I had a judgment of 3 judges of Supreme Court in my favor, other side had 3 judges judgment in their favor. So therefore it was sent to the 5 judges. Now 5 judges have finally concluded in the Dharampal case that magistrate has to apply his mind and see the content of the charge sheet and then send it.
Sir, as you rightly mentioned, mediation is a celebratory concept. But sir, it's still a very new concept in our Indian legal system, at least on paper. So, sir, what is that process or which is that ladder we need to climb to achieve those great heights in mediation or ADR precisely?
Then those matters which are referred by the court for mediation, they are sent to those mediation centers and to the trained mediators. Mediation legally is at a very nascent stage in India. But mark my words today, it is going to be the future. Because people have realized, like I said, you can't learn everything from your own mistakes. There are people who have a dispute, but they have seen their neighbor who had gone to court 23 years, 30 years back, and the matter is still lingering. One trial court decided, High Court, in High Court's appeals are pending for 20 years, 25 years. So that's the peril of going to court. So people are seriously considering, is it worth litigating for 30 years for the next generations to continue, or just set your ego aside, give up a part of your claim, but live happily in future. So that if we should, in the mediation, there's one magic sentence where the parties are not agreeing. One session, two session. So there's one sentence you should always use. Look, if the mediation fails today, the next date before the court is after 8 months. That itself is a deterrent. I have let's do something here only. So mediation is coaxing the parties, warning them. It's a very mixed. You can't just be goody-goody. Unko consequences समझाना है. If you don't do this is going to happen. If you don't do this, you'll go to jail. So डराना भी है, पुचकारना भी है, everything. You learn when you go through that 5-day course.
And sir, as a Supreme Court advocate, if you're fighting a case for your client and you lose that case, unfortunately, so sir, how does one deal with that feeling of defeat or that guilt? Because the stakes are too high. You're not just fighting for yourself, you're fighting for some other's life also. So how do you deal with that guilt? That because of maybe you in some way, the life of some other person is altered.
Guilt was in our heads first 2-3 years of the profession, where I had a good case, I was covered by Supreme Court judgment, I had documents of ownership in my favor, yet the judge dismissed it. So we would discuss that case with my friends in the canteen. Look here, I was covered by Zorawar judgment, Fulana section was in my favor, still he dismissed. Kai din tak, for days we used to be disturbed. But then we learned that apart from presenting the client's case in the best possible manner, there is nothing more a lawyer can do. So if I am satisfied that I put in my work, I argued all the points which were in my favor to the judge, before the judge, and still he did not agree, that's beyond me. So we don't feel guilty now. It's become, like for example, every profession, doctors have surgery hai, uspe bhi operation table pe deaths ho jati hain. You live with it. So there's nothing to feel guilty about it. But first few years, you will feel guilty. But then you learn that it's not your mistake.
An opportunity to enter public life, and if you have won the elections. So as a legal practitioner, what key aspects you would focus on your governance?
There is nothing legal I can do. For example, the constituency from where I had contested in 2009, it's a 100% rural constituency. No, not even a small town. So for them, what I used to promise them, also when I used to go around the villages, I can promise you one thing, that if I am elected for the next 5 years, you shall not have to pay a policeman, a thanedar, a tehsildar for your job, for your transfer. It will be zero corruption constituency. That change I had a vision of making if I had got the opportunity. Something legal offhand I can think of. I could have strengthened the legal aids. We had legal aid in every court. I would ensure that more competent lawyers are paneled on the legal aid panels, so that more effective representation is given. That's about that comes to mind.
Sir, and my another question is, before you answer, as you mentioned, tariq pe tariq is a very important skill. Buying time is in itself an art. So, what are those top 1, 2, 3 ways that always work? If not always, most likely are going to work.
I think it is on the spur of the moment. If it is towards 3:30 in the evening, court will rise at 4. 11 matters are still left to be heard. One mantra is, get up confidently, open your file. Lord, I will not take more than 45 minutes. The court doesn't have that time. Adjourn. Tariq. It depends. There is no set formula for it. That you learn with experience. 40 years. No, I have had experience of retaining clients whose cases I have lost. If the client, one thing I'll assure you, I'll advise you, as far as possible, ask your client, if they are not from very far away, to come to the court for hearing. Nowadays VC is available, you can send the link, provided it's allowed. The client should watch you address the court. He knows what his case is, he knows what are his plus and minus points. Every case is not 100% winnable, but he knows there's a minus point also. So if he hears you argue that you have prepared well, you have argued all the points which are in his favor, but the judge unfortunately pointed out, Mr. Counsel, come to page 73. That was one weak link in his case, and the judge caught it and dismissed it. So there he will not blame you that you have not worked hard enough. If you have put in enough work and he feels that you presented the case well, he will come back to you.
Spokesperson, you do not have a choice when it comes to taking up cases. So in cases where you feel like it is either morally incorrect to take up such cases, how do you cope up with it, or how do you deal with it?
Supposed to not refuse any case. Stray cases maybe, but you should not. That's what, when you become a lawyer, I believe there's a pledge that every citizen of the country has a right of, you have examples of Kasab and you name it. Everybody has been represented. In Ghaziabad recently some heinous matter was there. The Bar Association passed a resolution that nobody will from this bar will appear for him, and we will not allow anybody, any outside lawyer to appear. The Chief Justice of India summoned that bar. He said, look, individually you don't want to appear, but you can't allow him to go unrepresented. Otherwise the court will be compelled to appoint an amicus to represent him. So we are a democracy, a thriving democracy. However heinous the crime, he needs to be represented and heard. The court will punish him. We as lawyers are nobody to declare somebody a convict. That is for the court. You should not refuse a case.
So as you said, in the litigation field and mediation field, we need to have a lot of patience and consistency. And in the mediation field mostly, how do we need to handle clients? What are the traits a lawyer need to have to most like the emotional intelligence? Because not all clients come in the same mental phase or something, because some might be emotional, some might be like different kinds. What are the traits a lawyer or advocate need to have, how to handle clients in mediation or litigation?
Before I became an ASG, I used to do a lot of mediations in the Supreme Court Mediation Center. The procedure that we follow in Supreme Court Mediation Center is, both the parties are called. First, as a mediator, I meet one party individually. Then I meet the second party individually. I can now understand what is the difference. What is his demand, what is her demand, whether it is workable. Then I have a joint session of both the parties. And I suggest, look, you are asking for this, whether it's a custody matter or maintenance or business dispute or brothers. So then as a mediator, I give suggestions. After I give suggestions, I give them the consequences. If this is workable, around this if it is workable, or else this will happen. And then I give them an adjournment. Go home, discuss with your family, wives, children. Then they come back with because first day they are hot-headed, as if they are in court. They forget it's mediation. They think they have been called, they want to hammer it out there only. But once a viable option is given to them, they go home. On the next day, some do come with some sort of adjustment, agreement they are willing to do, some don't. But that's how it works, that's the procedure we follow. Like I told her also, you have to cajole them also, you have to warn them also, frighten them also sometimes.
Thank you, sir.
How does lobbying work in Supreme Court?
Good morning, sir. I am Adi Dhruvansh. Sir, has there been any case in your career that has changed your view on law, either positively or negatively?
Of Justice Sanjay Karol, where I was arguing for Government of India and tried to persuade him, but I could not. He has now passed a judgment saying 498A will be applicable to live-in relationships also. This, according to my view, the way I had tried to present my case was that 498A says husband or his relatives. That's very clearly set out by the Parliament. In a live-in relationship, there is no husband legally. Or forget that also. What I had tried to persuade Justice Sanjay Karol was, a live-in relationship, the two persons, they are not remediless. For example, if she beats him, there is an IPC provision. If he threatens her, blackmails her, but anything, every offence is covered under the provisions of Indian Penal Code. They are not remediless. They can go and file an FIR. Why 498? That is exclusive to husband and wife. But he was determined, and he has. I totally don't agree with that judgment. It's going to have very far-reaching consequences. And that's all I have to say.
But what are some things lawyers should not do or should avoid?
It is like saying what should a human being do, what should a human being not do. We are lawyers, we go to courts, we are social animals. So there is nothing that you should not do. Do everything that a human being is expected to do. Mehnat karo. There is nothing prohibited as such. Or is there any specific thing you wanted to say which I missed? What you should not do?
So, sir, litigation is a career usually people enter to deliver justice. But as we get into the...
I must tell you, at least I am not under any misconception that I joined this profession to deliver justice. All of us are going to join the profession to have a comfortable life. In the process, we may help clients get justice. So, and mention about anybody who's corrupt, who's not corrupt, I'm nobody to give them a certificate who's corrupt and who's not corrupt.
Sir, my name is DSNLU student. I feel like for corporate sectors or for law firm, we know where to start our career and how it can go, but for someone who wants to become a mediator, what do you think is the starting point? How should they start their career?
Being only a mediator is not an option. If I have given that impression, I'm sorry. Continue with your legal profession, whether it's in the corporate, or litigation. Spare time. Become a trained mediator. A time will come when mediation will occupy whole of your time. But not today. Today to practice your regular profession, corporate or litigation, whatever. But time will come.
Government's representative, you already have a lot of pressure because handling a government's case is a high-stake thing to do. So, handling that pressure, but at the same time, people who criticize the government and you being the spokesperson, you are in constant radar. Oh, this person was representing him. How do you see that situation and how do you handle those people when you find them criticizing you or being very critical of your work?
Talking about pressure, it is a pressure in the form that before I became an ASC, we used to represent individual clients. There the effect of the judgment of court would affect that one person. Here, when we argue, it's a policy decision. ACP, MACP, Assured Career Progression Scheme, whatever. So, that judgment is going to have pan-India effect. So, if the court holds that for Assured Career Progression Scheme, he should be given the next higher pay scale, irrespective of whether he is qualified, he has the qualification for the next grade or not. It's going to have effect on every government employee. So that pressure is there, that the consequences are very far-reaching. That pressure is there. But we have to live with the pressure. Given a little more hard work, a little more persuasive in the court, try to impress upon the judge, look, see the consequences it's going to have. So what the courts normally do is, when that fellow is really deserving, but the law is not in his favor. So normally what the courts do is, alright, we'll allow his petition, but then in the end they write, this order is confined to the peculiar facts of this case and will not be treated as a precedent. That line is our saving grace, so that in the next case we again argue that law point. That's a difference.
You gave example of Kasab. So Kasab was not citizen of India. He was someone who attacked India, like had foreign links. Why was he represented in the court by Indian lawyers? Like, can you explain that?
Does not have kangaroo courts. Anybody who is arrested in India, there is a law, there is a procedure, there are courts of law, there is fair opportunity. It is not that we condemn anybody unheard. It was to send that signal. And in fact, forget Kasab. Any foreigner who's caught here, his visa is expired, illegally detained, case is filed, legal aid is given to all of them. That's the beauty of our judicial system. Fair hearing, fair opportunity.
In transition to the higher courts or directly to the higher courts?
Addressing you. My advice is, you must spend at least 1 year in the trial court. Because except for the writ petitions that are filed straight in the Supreme Court, all, whether criminal, civil, every case has its germane in the trial court. So if you spend 1 year there, later if you even settle down in High Court or Supreme Court, the trial court is where the file gains its existence. Suit, reply, evidence, documents, admission denial, criminal, rose namcha, anything you name it. So once you understand that file, so after even the Supreme Court, when the file comes to you after sessions in High Court, you will understand the file. So 1 year in the trial court, I would advise.
Or is there any, should we always keep a connect with the higher
place to practice? There is nobody stopping you that you can go and sit in any court, High Court, Supreme Court, Trial Court. There is nobody stopping you. But according to me, the best court is where you can get work. For example, if I decide I want to practice in the Supreme Court, I go and sit in the Supreme Court. But where do I get work from? Work will come from high courts. So unless you have a wide circle of friends in the high court, the work will not come. So, like you give an example, a few years in the trial court and then high court. It makes sense. If you spend a few years in the trial court and then you shift to the high court, you will have a wide circle of friends in the trial court who matters are decided there. See, most of the litigation in India is by reference. When the client wins or loses a case, he has to go to the next higher court. He asks that lawyer, do you know somebody in the higher court? So if you have a wide circle of friends in the trial court, if you have practiced there, fair enough. You settle down in the high court.
What do you think we should focus on during our formative years here? So we can not only develop the legal knowledge, but also the ability to think and argue like a lawyer.
DSNLU first year. I wanted to ask, what is the misconception people have about Indian legal system, and what should, what law students should not believe. And I also wanted to know, there is a famous phrase, justice delayed is justice denied. So as the future lawyers, judges, what should we do to even make the matter even a bit better?
Had to argue a position you personally disagreed with? If yes, how do you handle that professionally and personally?
I am conveying my client's stand before the court. So, for example, some tenant is sitting in a landlord's property for 40 years at a rent of 200 rupees. And if I am for the tenant, certainly I don't agree. 200 rupees cannot place property 50 years. But in court I am only going to say what my client says, what is his contention, what are his documents he has. So a lawyer should never connect personally and emotionally with the facts of that case. We have only to represent the client's case before the court. I may disagree, agree that should not matter.
What do you think is the biggest misconception that us law students have about litigation?
Do you guys discuss that litigation is the last option?
No, sir. In your view, what do you think is what us students think that is the misconception that you think?
Actually, I will repeat. If you start litigation, it's going to take a couple of years for you to spend from your pocket. Because initially the clients that will come will be far and in between. But slowly, you see, in the legal profession, the only advertisement is by word of mouth by your clients. If you win them a case, if you behave properly with them, give them time, patient hearing, they will go home, sit with their friends and tell them, well, look, what's a lawyer there, na? Very nice. You won my case for me. Those four will tell, that's the only medium of, that's why it takes time. But once you are entrenched, then you are your own king. That's the beauty of
litigation. What is the motivation that keeps the litigant going further and working harder?
More money.
But there are hurdles in the career. So, money can be one thing, but what if the money also keeps stagnant? Like, there are hurdles that I've heard of in litigation where money is slow, but then
it is slow initially. That there are.
Thank you for your valuable insight, sir.
Namaste, sir. I am Likita Abhishek from first year, 5 years LLB. My question?
I was foolish. When I started my practice in Supreme Court, like most young Supreme Court lawyers then would do, they would visit the high courts because it's from there the matters of Supreme Court will come. So, keeping that tradition up, I had gone to High Court of Punjab and Haryana at Chandigarh. So I was sitting at a coffee table with few of my friends. Two lawyers were passing by. One of the lawyers sitting on my table said, "Arey, these guys have again come from Supreme Court to collect briefs." He said that in a very demeaning way. I took it to heart. After that, I never went to Chandigarh High Court. But I should have ignored it. That's the High Court from where my work used to come. So you should be thick-skinned, ignore such people who are trying to, demean you. If work from Supreme Court comes from High Court, you have to have a wide circle of friends in the High Court. And if you are practicing the High Court, work comes from trial court. You have to go to trial courts, and that's the reality. You can't just sit in a iron castle in Supreme Court and wait for work to come. Initially you have to reach out. You reach a stage, there constant flow will start. I had a wonderful faculty. there's nothing that is taught can ever be waste. Nothing. In some form or the other, it will help you. Thank you.
Thank you for all the questions. As we come towards the conclusion of today's program, it is now time to express our gratitude to everyone who has contributed to make the occasion possible. May I now invite our respected Registrar in Charge, Dr. Vice-Chancellor Prakasa Rao, to deliver the vote of request to kindly address.
Good morning all. Good morning sir. I express on behalf of DSNLU, I express my deep gratitude for accepting our invitation to be here for interacting with the students and sharing your valuable insights on legal profession and from your life experience and answering all the questions. Very insightful answers.
I rejected one.
Yes. Very patiently answered the questions, all the questions. Yeah. I thank all the students who asked the questions, all the questions for all. I also thank you to Honorable Vice-Chancellor for arranging the session for the benefit of students. And I also thank you to all students, friends for your active participation and also my faculty members, staff who are present here. Thank you all for that.